Hello, my name is Luke Mace, and my PowerPoint presentation that I'm going to narrate has to deal with sexual harassment in the workplace. So first I start by defining sexual harassment. The EEOC, which stands for the Equal Employment Opportunity Committee, defines it as unwelcome sexual advances or requests for sexual favors and other verbal or physical conduct of a sexual nature that takes place in any of these conditions, where submission to the terms which I listed above is a condition in the employee's contract for hire, and also lack of submission to the terms is a condition for termination or the basis of employment decisions for the employee, such as future promotions or raises. The three main ways to prove that you as an employee are being sexually harassed. The first would be quid pro quo, and this is when you are refusing an advance that has a direct impact on the employee's hiring, promotion, demotion, or termination. Hostile environments are the second thing that are created by supervisors, and this is used when there's no tangible consequences such as demotion, but still one can feel emotional and psychological distress, which has substantial effect on the employment and the production of the employee because they're feeling uncomfortable and there's a lack of motivation. Hostile environments caused by coworkers or employees is when lewd comments, for example, caused by required quote-unquote sexually provocative uniforms are used for women employees on the job. The penalty falls on the employer if they knew that the situation with the non-supervisor employees was going on with these lewd comments and they failed to address and deal with the situation. So that leads us to the next question. When is an environment hostile? And so the courts look at whether or not discriminatory conduct is frequent or severe. They also look at whether it is physically threatening or humiliating to the employee, and finally whether it is unreasonably interfering with the employee's work performance. So the implications of the ruling, this is when the employer is trying to show that they are not at fault for the sexual harassment lawsuit that might be brought against them in a court of law. So with quid pro quo, the employee does not have to have suffered a tangible job action, such as a demotion. The employer must show that it took reasonable care to prevent and correct any sexual harassment behavior from the two parties involved. Then the employer also has to show that they've attempted to correct the situation and have dealt with the behavior, and that the plaintiff unreasonably failed to take advantage of any preventive or corrective opportunities provided by the employer to not allow this action to continue further. Some of the key Supreme Court decisions on sexual harassment, the first would be the Meritor Savings Bank, FSB versus Benson, and this was first used to define sexual harassment. Second was Burlington Industries versus Ellerth, which helped define quid pro quo. Finally, Farragher versus City of Boca Raton defined the hostile work environment. And so the main reasons why no action is pursued by the harassed employees, the first reason is that women perceive social sexual behaviors as harassment, and so there's just a general tendency to wave off when a woman approaches their manager or human resource director and says that they feel that someone was making them feel uncomfortable by a hand gesture or touching their shoulder. The second main reason is the fear of repercussions and distress felt by the individual filing the claim, because usually the workplace is small, so rumors can spread very fast, and with something like this could cause a hostile environment caused by the employees rather than the manager, where the lewd remarks, which I mentioned in a previous slide, could occur. And so finally we come to what the employee can do when they're placed in this situation. And so the first thing that is looked at when an employee files a claim is how soon was it done. And so ideally you would want to go right away after something has occurred and make sure that it's well documented and that you didn't wait a few days and let time pass, because that can affect the perception on your claim. So ideally, the first thing that an employee should do is file a verbal contemporaneous complaint with the harasser and the harasser's boss, stating that the unwanted overture should cease, and that is followed up. If that unwelcome behavior isn't stopped, then they should file verbal and written reports with the Human Resource Director. But I would like to say that the first thing is recommended, but it's not vital to do that particular step, because in the case that you are in a small work environment, the harasser's boss might be the actual harasser, and so it might be someone that you can't follow that chain of command with, and so you would have to skip them and go directly to the Human Resource Director. And so if the final step would be just, if you had gone to the Human Resource Director, you filed your claims, and if letters and appeals to the employer don't suffice in this case, then the employee should turn to the EEOC to file a claim. In severe cases, the employee may wish to speak to an attorney to sue the employer for assault and battery, intentional infliction of emotional distress. There are also smaller departments, state departments, that deal with these type of claims, so they may wish to turn to those first and then finally the EEOC. But usually the smaller state department organizations can deal with these claims sooner than the EEOC. And that concludes my presentation on sexual harassment. Thank you.